Okay, today we are diving into a really unexpected mashup. We're going to look at how the timeless, completely nail-biting mechanics of classic cinema directly map onto the high-stakes, hyper-real world of law, independent audits, and white-collar crime. It's this absolutely fascinating overlap between the psychological architecture of fear and the rigid, black-and-white structure of the American judicial system.
So you gotta wonder, what exactly does the master of suspense, Sir Alfred Hitchcock, have to do with white-collar crime and defamation law? I mean, at first glance, you might think absolutely nothing, right? One is pure Hollywood entertainment, and the other is dry legal bureaucracy. But stick with me, because by the end of our time together, you'll see how a Hollywood director's theories on fear perfectly describe the agonizing panic corrupt officials experience when they are finally exposed to the cold, hard truth.
All right, let's jump right into Act 1, the architecture of suspense. So born in 1899, Hitchcock had this very strict Jesuit upbringing that profoundly shaped his worldview. It instilled in him a really deep moral complexity and, crucially, this paralyzing fear of authority and an ever-present sense of guilt. And these anxieties literally fueled his entire career. You can follow his progression right from the start, using his technical precision to design silent film title cards back in 1919 to directing Britain's very first sound film, Blackmail, in 1929. By 1940, he's making his Hollywood debut with Rebecca, which casually wins Best Picture. And then, of course, in 1960, he fundamentally alters the entire horror genre with Psycho, basically forcing audiences to confront their own hidden pathologies.
46. That is an absolutely wild number of total Academy Award nominations his films racked up over a career spanning more than half a century. Yet despite all this immense commercial success and being literally everywhere on culture, a lot of contemporary critics initially just viewed him as a highly skilled technician, a mere entertainer. It actually took French filmmaker François Truffaut's landmark 1966 book, which was based on a solid week of interviews, to really validate Hitchcock's work. Truffaut pulled back the curtain to reveal the profound philosophical depth and meticulous visual grammar behind the movies, finally cementing Hitchcock as a true artist, an auteur.
And this brilliantly illustrates his core directorial philosophy. Just imagine a sudden shock for a second. A bomb explodes under a table out of nowhere. Boom! That gives the audience about 15 seconds of surprise. Now consider Hitchcock's famous alternative. The audience is actually shown the anarchist placing the bomb. We see the ticking clock right there beneath the table, all while the characters are having some completely mundane conversation above it. We have critical information that the characters totally lack, and that generates 15 minutes of agonizing suspense. Maximum tension isn't achieved by a cheap shock, it's achieved through dramatic irony and maximum disclosure to the audience.
Moving right along to Act 2, the intrusion of the real. The philosopher Slavoj Žižek uses Lacanian psychoanalysis to explain this Hitchcockian horror, and he notes something really profound. The ultimate terror isn't some supernatural monster hiding in the closet. It is the intrusion of the real. In our context today, corrupt officials and institutions live in this highly curated symbolic order. It's a fragile, totally fabricated public image kept alive by slick public relations and bribery. So their absolute greatest fear? It's the devastating intrusion of verifiable truth that violently shatters that false reality.
Okay, let's dive into this comparison because it is spot on. Hitchcock explored the pathology of voyeurism in Rear Window, right? You have the wheelchair-bound L.B. Jeffries using a telephoto lens to peer into his neighbors' lives and eventually uncover a hidden murder. Well, over in the corporate world, the independent forensic auditor functions exactly like that cinematic detective. The auditor meticulously peers into the financial subconscious of a corrupt enterprise. We're talking the spreadsheets, the shell companies, the offshore transfers. Both the cinematic voyeur and the forensic auditor violently strip away a curated societal facade to reveal the brutal pathology hidden right beneath the surface. So what happens when that auditor actually shows up? Well, the audit literally becomes Hitchcock's bomb under the table. The corrupt official knows full well the illicit transactions exist in the records. So the second the auditor starts sequentially requesting evidence, that ticking clock is initiated. The official has to sit there in press conferences and board meetings pretending everything is completely normal, literally performing innocence, while privately anticipating the exact, unavoidable moment the factual bomb is going to explode. It is prolonged, paralyzing suspense, and honestly, it's far more terrifying for them than a sudden, unpredictable arrest. All this suspense culminates in a psychological concept Žižek calls the point de capitan, the quilting point. In Hitchcock's films, it's that one detail in a perfectly idyllic scene that just doesn't belong, like, say, a windmill rotating against the wind. For the official under audit, it is the singular forensic anomaly. It's that one missing receipt, a misaligned date on a procurement contract, or some unrecorded asset. That one loose thread is all it takes. It exposes the obscene corruption teeming beneath the surface and completely unravels the entire fabric of their false reality.
Which brings us to Act 3, the climax in court.
Now, when cornered, corrupt officials deploy a very predictable sequence of evasion. First, using what academics call fantasy theme analysis, they try to construct a competing rhetorical vision. Whether it's politicians siphoning funds or executives violating procurement laws, they predictably claim they are the victims of a partisan witch hunt, just completely dismissing hard evidence as fiction. But when that PR spin fails, they take the ultimate desperate step. They file a strategic lawsuit against public participation, or a SLAP suit. And look, the goal here isn't to actually win on the merits. No way. The goal is to burden the auditor with exorbitant legal costs and endless discovery until they just give up and abandon their scrutiny. They are literally trying to get a judge to legally mandate that truth is fiction.
Now, what's really interesting here is how American jurisprudence actively blocks that exact maneuver. Defamation law exists at this highly volatile intersection of protecting a person's reputation and preserving First Amendment rights. So, while an everyday private figure only needs to prove negligence, basically just a failure to exercise reasonable care, a public official faces a massive evidentiary hurdle. They must prove actual malice with clear and convincing evidence. And let me tell you, this standard is monumental. Established by the Supreme Court way back in the 1964 case, New York Times Go v. Sullivan, actual malice actually doesn't mean personal ill will or spite. It requires rock-solid proof that the publisher either had direct, subjective knowledge that the statement was blatantly false, or they acted with reckless disregard for the truth. It is an incredibly high threshold, designed explicitly to protect robust, uninhibited public debate. It makes sure public figures can't just easily recover damages simply because they are embarrassed by a factual investigation. Furthermore, the law constructs these really robust shields of privilege to protect the free flow of vital information. Whether we're talking about absolute privilege, which grants total immunity during judicial or legislative proceedings, or qualified privilege for good faith statements on matters of legitimate public concern, there's also the fair report privilege protecting the accurate reporting of public records and court dockets, and of course, Section 230 immunity for internet service providers. All of these privileges are specifically built to prioritize societal transparency over an individual's bruised ego.
Ultimately, and this is absolutely crucial, substantial truth operates as an absolute, complete defense to any claim of defamation. Fun fact, this doctrine actually predates the American Revolution. Basically, if the gist or the core assertion of a statement is factually accurate, minor peripheral mistakes do not magically render it defamatory. If an accusation against a corrupt executive is totally supported by verifiable facts and actual financial ledgers, liability simply cannot attach. The courts categorically refuse to penalize individuals for disseminating documented reality. And to enforce this, to really give it some teeth, jurisdictions deploy anti-SLAP countermeasures, like the Texas Citizens Participation Act. These statutes act as the ultimate legal plot twist. When a corrupt official files a frivolous lawsuit just to silence an auditor, the auditor can immediately file an early motion to dismiss. This instantly halts all that costly discovery. The burden then violently shifts right back to the corrupt plaintiff, who now must instantly present clear evidence showing a high probability of success. But because the underlying audit is based on verifiable truth, and let's face it, a ledger cannot be cross-examined into non-existence, they inevitably fail. Their case is swiftly dismissed, and, get this, they are ordered to pay the auditor's legal fees. Talk about backfiring.
Which leaves us with this final thought. We've seen how Hitchcock artificially simulated horror on the silver screen to thrill audiences. But we've also seen that the most profound terror for a corrupt entity in the real world is the inescapable exposure of the documented real. Objective truth, fortified by legal privilege, absolutely remains the lethal antidote to corruption. So, ask yourself, if undeniable facts are the ultimate terror for the corrupt, how can we better protect the independent auditors and investigators who brave the darkness to expose these curated fictions? Thank you so much for exploring this with me today, and definitely keep questioning the fictions around you.